This is a presentation on intellectual property and patent law, uh, centered on comments from an interview with the New York patent lawyer Tom Bengara, presented by Dwayne Amos. Tom Bengara is a graduate of Brooklyn Law School, and he's an associate attorney at an intellectual property law firm in New York City. The name of the firm is omitted here for anonymity considerations. Um, okay, so we spoke with Attorney Bengara, and he gave us some insight into the patent, trademark, and copyright world. Regarding challenges, he said one of the major challenges is just staying on top of recent developments in federal circuit law. Um, the circuit courts are throughout the year on a number of occasions will review matters regarding um, patent, trademark, and copyright law, and those decisions will be binding on the lower courts. So it's important that the attorneys stay up to speed with these decisions. Additionally, it's important that the attorneys and the people in charge of the legal interests in a company remain current with the issues in the federal court practice. We'll see later on in the presentation. This can regard things like discovery and the federal rules of civil procedure and things like that. Um, and again, these are just in general considerations regarding how a company might make preparations and protections for their interests regarding copyright, patent, and trademark legal issues. Mr. Bengara spoke on some common mistakes that companies or individuals can make regarding these issues. One being failing to protect against in-house liabilities. And basically there they're talking about employees or former employees. So when you're in a business that relies on copyrights and trademarks, and you have numbers of employees that are working perhaps on filing for those licenses and registrations, and they were to perhaps leave the company, and if they were unhappy, they might testify against the company and against the company's interests if there was ever a suit brought regarding those licenses and registrations. In addition, he talked about waiting too long to seek legal advice. And basically, underneath that note, he mentions you want to get legal advice from day one. The actions basically leading up to the date of conception or the invention. So if we're talking about copyright, to the date that the material is produced or published. Even the actions leading up to that are going to come under scrutiny during the litigation. So, as early on in the process as possible, if you can get some legal advice on how you can protect yourself, put structures and things in place so that if a litigation does come up in the future, you have as much protection and limited exposure as possible. And then just going on to talk about legal action in general. And Mr. Bengara talked about some of the federal rules regarding discovery are changing in the direction of requiring more focused requests. We talked a little bit earlier in the presentation about that concept of just staying on top of changing federal regulations, rules, and things like that. So here he's just basically talking about the fact that people making broad discovery requests when the litigation comes up involving copyright or trademark or patent issues, those broader discovery requests are being rejected. So it's important that these issues, when they are brought to litigation, that your request can be pointed. And again, that just basically highlights why it's important to get that legal advice as early on as possible. So just summarizing again, it's important to remain current and up to speed on the legal issues. We have to protect against some in-house legal liabilities, seek legal advice as early as possible, and consider federal discovery rules. Thank you. And again, this is Dwayne Amos, presentation on intellectual property and patent law.